Jaspreet Singh, Honorable Dr. Lakhveer Singh, Principal, Baba Banda Singh Bahadur Engineering College, Fatehgarh Sahib. Respected Dr. and convener of this webinar, respected faculty members, dear students, and other esteemed members from various institutions, on behalf of Baba Banda Singh Bahadur Engineering College, Fatehgarh Sahib, I, Professor Parvinder Kaur, would like to welcome you all to this webinar on the topic Modern Day Intellectual Property, organized by the Department of Computer Science and Engineering, Baba Banda Singh Bahadur Engineering College, in association with BBS BEC ACM Student Chapter. I thank you all heartily for taking the time to join us today. Now I humbly request Principal Sir Dr. Lakhveer Singh to present the welcome address. Sir, please.
Mr. Jaspreet Singh ji, Head of the Department, faculty members, and other participants, very good morning to everyone. On the behalf of Baba Banda Singh Bahadur Engineering College, I welcome Speaker of the Day, Jaspreet ji, to this webinar, and
Thank
other
you,
participants. And as the title of the webinar is Modern Day Intellectual Property Rights, Jaspreet, I think it is regarding the copyrights and patents.
Yes, sir.
Yes, these intellectual property rights as well as the patents, their knowledge is very important in these days, because whenever we go for a research or we are going to write a new thing, we must know how to get the patent on the new invention and how to get the property rights, intellectual property rights. These are the very hot topics. And I am also thankful to our CSC department, head of the department and faculty members to organize this webinar so that our students and faculty will get knowledge about the intellectual property rights and patents. And without wasting much time, I will again welcome Jaspreet ji to this webinar, and I request to proceed further. Thank you.
Thank you so much, sir. Intellectual property with special reference to patent plays a vital role in enhancing the socio-economic prosperity of the country. It enhances motivation to disseminate scientific and technological information, which in turn stimulates research and development activities for the improvement of the quality of life of the people in the nation. To enlighten us on this very crucial topic and to provide us with an understanding of the basic concepts of IP and the significance of IP protection in the context of the current developments, we have with us an entrepreneur, Mr. Jaspreet Singh, founder and CEP of New Delhi. Mr. Jaspreet Singh did his BTech in Computer Science from Punjab Technical University. He began his career in IP at around 2011 and has not stopped his progress since then. He has performed many managerial responsibilities pertaining to developing, implementing, and continuously improving the best-in-class procedures and systems for IP management in organizations like Verispire Technologies Private Limited, Noida, and Patent Maniac Consulting Private Limited, New Delhi. In his experience of 10 plus years, Mr. Jaspreet has trained more than 100 professionals in patent writing, resulting in vast exposure to multiple domains like computer science, mechanical, telecommunications, cloud computing, AI, big data, product design, and to name few. And has provided assistance in the development of IP asset management, digital tools for the efficient management in research hubs and academic institutions as a part of faculty development programs in other various institutions. So, with a big round of applause, please welcome Mr. Jaspreet Singh. Sir, it's really nice to have you here. Thank you for sparing your time to be a part of this webinar. Now, I request you to please start the session.
Thank you, ma'am. Thanks, Paminda, ma'am. Thanks, Lakhveer, sir, for the introduction. Thanks a lot for giving me such time for this session. I hope my screen is now visible to you. The presentation is visible to you.
Yes, sir. Yes, sir.
So let's start without wasting much time. So the topic today I'm here to discuss about the intellectual property. What is intellectual property? What are the types of intellectual property? And what are the rights on the intellectual property? How we can, what are the time duration or enforcement period related to specific type of IP? So, as ma'am already introduced me that I'm being an IP specialist or intellectual property specialist working with quite few faculty members, or I would say around 100 to 150 faculty members around India, and helping them from ideation to grant, and in some cases up to funding also. We are, along with this, we are working with some US law firms also and helping them in their intellectual property also. So today I will be discussing about the basics of IP. What is IP? What is IPR? Types of IPR, how they are different from each other, how it is useful to you, how you can generate your IP, some infringing examples. So let's start without wasting much time. So if I talk about IP, intellectual property, what do you mean by IP? What do you mean by intellectual? In a layman language, we have around 60 to 70 participants are here. If anyone can answer my question, what do you mean by intellectual in a layman language? And what do you mean by property in a layman language? Intellectual property, what do you mean by that? Intellectual. And the intellectual means basically any idea that is created or invented by someone, any innovative idea. Property is in a layman language, we say any tangible thing that belongs to you. The land, your house, or maybe the land in which the college is located belongs to the authorities or the owners of the college. So property is something tangible. Intellectual means something creative or innovative idea invented by the applicant or the owner or the assignee of that idea. So intellectual property, it's basically ideas created by the applicants. If you see around yourself, you have multiple IPs around yourself. You have mobile phones with you, you have laptops with you, you have mouse with you, you have uh, uh, your that speakers, your headphones, your earphones, your televisions, air conditioners, everything around yourself, your books, research articles, everything around yourself is a type of intellectual property. So what do you mean by intellectual property rights? Basically, intellectual property rights are the rights or the claims that you try to have on your invented or your innovated idea. Rights is basically claiming something that this IP belongs to you. IP rights, intellectual property rights, IPR rights. It is basically rights given for a particular type of IP to the applicant for a certain duration. So intellectual property rights are the rights given to the applicant for a certain period. So IPR rights can be on books, can be on software codes, music, songs, advertisements, your inventions, innovative ideas, and many more. So all the things that you are using in your daily life is a type of IP, and someone having their IP rights on it. If you're using Samsung or Apple mobile phone, they have the design is a kind of IP that is being owned by Samsung or Apple. Or If I talk about the automobile, in the automobile sector, someone is using Tata product, someone is using Hyundai product, someone is using Honda product. So every automobile is having some rights. Every automobile company having some rights over their product. So IPR rights is basically a rights given to the applicant for a certain duration, depending upon their invention or depending upon the work product. Today we will be discussing about few types of IP that including copyright, trademark, geographical indication, patents, design, trade secrets, plant varieties. So many of you must have some knowledge or some maybe know something about this. So we will be discussing few of them. The first is trademark. A trademark is a word or a phrase or a brand name or a symbol or a logo or a mascot. Look around yourself. You are using multiple brands. You are using Samsung, you are using Apple, someone is using OnePlus, someone is using Hyundai or Honda Activa two-wheelers. Someone is using Hyundai cars. Someone is using air conditioners of O Journal, Carrier. All these are trademarks. All these are brand names. So basically, a trademark is a brand name or a word or a logo or a phrase that is given for a period of 10 years, and it can be renewed before the completion of 10 years up to indefinite period of time. So suppose if your trademark is going to lapse on 4th of March 2022 or 5th of March 2022, you can renew before it, maybe by 4th of March 2022. Nike, Reebok, KitchenAid, Indian Airlines, Air India, many trademarks many brand names So all these brand names are kind of belongs to trademark, or I would say these are logos of their quite known companies. If you have any startup, or maybe this college is having a logo, Baba Banda Singh Bahadur College is having their own logo. My company is having my own logo or a brand name or a product name. So this is basically a type of IP, intellectual property rights, given to the applicant or the owner of the trademark for a period of 10 years. Like in every schools, every education sector, we have different classes for different domains. And this also, in trademark classification also, we have 45 classes, and every class is distinguished from each other depending upon the domain. Class 45, for example, class 45 is into legal consulting. Class 41 is into education sector. Class 36 into monetary transaction. Class 18 is into something related to biotech. Class 1 is related to something used in chemical industry. So every specific brand name or product belongs to a class. पेप्सी ये दिल मांगे मोहन मेंटोस दिमाग की बत्ती जला दे मैगी टेस्ट भी हेल्थ भी हेवल्स शॉक लगागा all these are types of trademark into having different classes because of their different domain. Basic rule for filing a trademark, for getting a trademark, not filing a trademark, that similar pronouncing name or homophones won't be getting a trademark. It's not like we can't file for it. It's we won't be getting our patent, our trademark application will be rejected if similar pronouncing names or homophones are there. I taken one example of empty. If I remove e from the starting and pronounce it, it will come like empty. Now I am removing y from the last, again empty. And now I am removing p from the middle, empty. So if I pronounce all these trademarks empty, 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 these are homophones. So my trademark application will be rejected in this case if these homophones are already there in the market. A few trademark infringement case. First is PayPal against Paytm. Everyone knows about PayPal. They are into the market from 1998, 1997. And PayPal is into industry of online transaction. And Paytm is into the same domain. If you see the similarity between the logo of PayPal and Paytm, it's dark blue plus light blue color. And again, the initial is same, pay. So PayPal accused Paytm that they are using similar color combination and having similar initials of pay, and they are into the same industry. So because of using Paytm, because of using this name Paytm, the business of PayPal is being affected. So the case is still going on. Another case is a coffee chain, quite known coffee chain, Starbucks, filed a case against a local Delhi-based coffee chain, Starbucks. See the similarity between Starbucks and Sardar Baksh. So the Indian Trademark Office asked the owners of Sardar Baksh to change their name from Sardar Baksh to Sardar G. Baksh. Again, similar pronouncing names or homophones are not allowed for having a trademark. So I have a question at the right top side, I mentioned BlackBerry and BlackBerry. So how come the second BlackBerry into the apparel section got a trademark, whereas BlackBerry into the electronic domain was already there? Any answers to it? Any one of you can answer my question. How come a similar pronouncing name or homophones was given to BlackBerry into the apparel sector? Any one of you can answer
So
my
it's
question?
because they operate in different industries.
Yes, ma'am, exactly. Because they have different classification. BlackBerry into the apparel section is not affecting the business of BlackBerry into the electronics domain. That is the only reason they are into different sectors, and still a similar type of trademark or homophone is granted to the owners of the BlackBerry into the apparel section. Another example is, if you can see the similarity between the Oreo and Fabio. Not only the keyword is essential in trademark, the packaging look is also covers under trademark. So the owners or the company Oreo filed a case against Parley for the product Fabio. Look at the similarity between the product. So they have filed a case against Fabio because of this, the business of Oreo is being affected. Why it is being affected? See the similarity between the packaging. See the similarity between the overall appearance of the product. That is the only reason. Saurabh, Saurabh. Similar pronouncing names or homophones. Belseri, Belseri, Bisleri, Bresley. All are these are trademark infringement example. Nike just do it, Nika must I make do it. McDonald's, both are into different classes. Another term is brand enforcement. I have not mentioned here, brand enforcement is basically selling out some known product, selling out your own product using some known name. I can give one example that when you visit visit a store, offline store, the cost of one footwear, maybe I take one example, the cost of one Nike footwear over any e-commerce platform is around 4,000 to 5,000. Whereas the similar shoe or similar footwear, when we visit a store physically, the cost is around 8,000 or 9,000. So why there is a difference between the cost? We say that because first of all, when we are going for online shopping or we are using any e-commerce website, the products available there are kind of first copy of the original product. So this is kind of is a term known as brand enforcement, that I am Jaspreet using the name of Nike and selling out my own footwear on Amazon or Myntra or any e-commerce website. So वो सैमसंग का सैमसंग हो जाता है, नोकिया का नोका हो जाता है. So there is a, that is, here comes the brand enforcement terms comes into picture, that someone is using your name and selling out his own product. So this was trademark. Any questions regarding trademark till now?
Yes, participants, you can ask questions or you can post your question in the chat.
Okay, I'm continuing right now. So if someone wants to ask any question, can ask me at any time. So the next part is copyright. Basically, this is also a type of protection. Every IP, every intellectual property rights is a type of protection. Trademark is for brand name. Copyright is basically for artistic or literature work, not for your invention. So copyright is also a type of intellectual property rights. The rights are given to the applicant or the owner for their artistic or literature art. And examples that are being covered in copyrights are basically music, songs, software codes, architectural drawings, programs, databases, advertisement, cartoon characters, many things, landscapes, all these are covered into copyrights. So the enforcement period of copyrights is the life plus after the death of 60 years after the death of the person. So I can give you one example that Amitabh Bachchan is still using the poetry of Harivansh Rai Bachchan. So this is a type of IP, basically a right given to the applicant for their artistic or literature art. Recordings, dramas, your research papers, movie writing, all these are covered into copyrights. So one copyright infringement case was there. Everyone know about Bala and Ujra Chaman. So the makers of Ujra Chaman filed a case against the makers of Bala and accused the makers of Bala that the makers of Ujra Chaman was in talks with the makers of Bala from 2013. They have narrated the story to the makers of Bala way back in 2013. But at that point of time, they were not interested in this kind of story. But as already you know, everyone knows that the similar kind of story concept was in both the movies were used. So the makers of Ujjwala Chaman filed a case against the makers of Bala for this. Another European artist, Flora Bossi, accused the makers of Judgmental Hai Kya for using a similar, for copying their poster work, artistic, photograph. See the similarity between the poster of Judgmental Hai Kya and the artistic work by Flora Bossi. Another copyright infringement case was filed by Teps Industry against Wink Music. So everyone knows about Wink Music. Wink Music is there, SoundCloud is there, Ghana is there. Many apps are already there that provide their user to play or to stream the music or particular songs for free. So there was a deal between Tips Industry and Wink Music that Wink Music will play all the songs that was uh, Tips Industry was having the right over it. But Wink Music breached the agreement that was being signed with the Tips Industry. Wink Music allowed their user not only to online stream the songs, but to download the same songs for free of cost. But in the agreement between Wink Music and Tips Industry, it was not written anywhere that the Wink Music will allow their user to download the songs. So royalties were being paid to the Tips Industry by the Wink Music. Another case is quite familiar with everyone around yourself that suppose many songs or many DJ parties are going around yourself. So is it authorized or it is authenticate enough to play all these songs over any party or on any DJ? Is it any? Do you have any permission to play any songs on any music platform? Suppose I'm launching any. I can give you one example. There was a show, India Got Talent. So there was a participant, Akshat, who who dances on the songs of Salman Khan movie Dabang. But when this same Akshat went to Britain Got Talent, so the Salman Khan films rejected or dismissed or didn't give the permission to Akshat to play their songs in Britain Got Talent. So ethically is not allowed. This is not allowed to play any songs over DJ, but unethically it is available over the web, unethically is available over YouTube. Every song is available over the YouTube. So no one can stop you. No one can file a case against you if you are playing, if you're taking royalties or you are using this any kind of monetary benefit out of it. Another question is right now every PDF of every launched novel is available over the web. Many Chetan Bhagat novels are available over the web free of cost. Many other novels are available over the web in a PDF format free of cost. So, can we file a case against them? Can we file an infringement case against them that someone is selling out their authentic work product for free? Or some at some platform, some books are available in the PDF form. In journal, we can file or we can sue anyone who is using your work product without your consent. But for that, you need to have a proof of that. You need to track down by your own that who are the ones who are using your product. I was giving example of Chetan Bhagat, but who will be tracking down all the links where the novels of Chetan Bhagat are available? Who will be tracking down the books that are available in the PDF format? So the tracking the infringing party is quite a problem or a time-taking process. But if you know someone who is using your content without taking your permission, or I would say if you know someone who is using your protected content without taking your permission, you can easily file an infringement case against them. So this was copyright and trademark. Anyone having questions regarding copyright and trademark can ask me. Anyone having questions?
Yes, participants, you can ask your questions. You can unmute yourself and ask the question if you have any.
There's a question, what we have to do for copyright. Basically, there is a form. First, what you want to copyright, literature content or artistic content, what do you want to file for? And you can easily do by visiting the Indian copyright website. You can file for yourself, or you can consult any consulting firm that will help you out for filing your copyright. But it depends. You want to file your any literature art, you want to file your any music recording, what do you want to file? That totally depends upon you. कंटेंट क्या आपका क्या कंटेंट है वो आपको पता है, बट कंटेंट के हिसाब से फीस होती है. कंटेंट कितना है उसके हिसाब से फीस होती है. सो दैट टोटली डिपेंड्स अपॉन यू व्हाट इज द कंटेंट. You can file for yourself. You can file by yourself also. So Indian Copyright Office. Anyone else? So after the death of the person, the copyright is inherited to your family. मतलब कि अगर आपका बेटा या बेटी कोई भी है फैमिली में, तो वो आपका कंटेंट यूज कर सकते हैं. उसके अलावा जैसे एक नॉर्मल प्रॉपर्टी होती है लेबल लैंग्वेज में, इफ आई यूज लेबल लैंग्वेज, व्हाट डू मीन बाय प्रॉपर्टी, कि आपके बाद आपकी फैमिली यूज कर सकती है, उसके बाद उसके ऊपर किसी का राइट नहीं है. सिमिलरली इन कॉपीराइट केस दैट only your family members can use it, not anyone else. There is no procedure involved in any procedure involved in it. It is a automated process. Another question is, as you mentioned, copyright material can be available online easily, illegally, which is difficult to track and take down. Is there any point in filing for copyright? Yes, sir. Why not? Sir, basically, That totally depends upon you why you want to file a copyright. If you want to uh, suppose I'm coming up with some video series or video lectures, and I don't want someone to use my content. I don't want someone to use my video content basically. So I will certainly go for copyright. What is your call? What do you need from that copyright? It's not like that everyone should file copyright. What is your need for filing a copyright? There is no harm in filing a copyright. At least you have some protection over your content. You can easily ask anyone. If you know someone that using your content, you can easily ask someone to take down it if you know it, because you are having that protection. If you're not having your protection and you know someone that using your content, no one will listen to you regarding your content. So if you want someone not to use your content, you can file for a copyright. Any other question, or shall I proceed? So the next type of IPR, intellectual property rights, it is also a kind of protection. Basically, a design. What do you mean by a design? If I ask you in a layman language, what do you mean by a design? Forget about IP. What do you mean by design? Anyone of you? Any? We have around 40 participants right now. Any one of you can answer my question. What do you mean by design in a layman language? Basically,
Design can be considered the form of something, the shape.
yes. Basically, a design in a layman language, we say the shape or the design or the structure of an item or product. So a design is also a type of IP or intellectual property rights that is given to the applicant or the owner for a period of 15 years in India. So I'm saying design of a product, design of a jewelry, design of a furniture, design of a beverage container, design of computer icons. I'm not saying the functionality. You have mobile phones with you, everyone having multiple mobile phones. So some mobile phones having charging port at the bottom, someone having at the right, someone having at the left, someone having at the bottom. Some mobile phones having a volume button at the right, someone having at the left. So every mobile phone is distinct in terms of shape, in terms of the overall appearance. I'm not saying the functionality of that mobile. I'm saying the appearance, the overall shape of that product. A chair with a four leg, a chair with a five leg, a chair with a six legs. All these chairs are distinct from each other. Again, I'm not saying the functionality, the overall appearance of a product, design of a shoe, design of a stroller, design of a tire. There are around 8 lakh tire design in the world. Again, I'm not saying the functionality. Design only covers the shape of the product, not the functionality of the product. Design of an automobile, design of a handbag. See at the right side, SUV vehicles, Ford, Hyundai, BMW, Porsche, Toyota, Jeep, Nissan. Every SUV vehicle is different from each other. We are using mobile phones. We are using mobile phone covers also. Someone is using only back covers, some are using flap covers, someone are using flap covers with pockets, some are using flap covers with the zip to lock or unlock the phone. Again, the zip is not the functionality. I'm the appearance of the product. A design of a bag, a design of a frame, design of the apparel you are wearing. Maybe someone is wearing checks, someone is wearing maybe some standing or horizontal lines, maybe anything. The appearance of the product. Design of a dustbin, design of a Visa card, design of a shoe, design of apparel you are wearing, design of the cutlery. Only the design, the appearance of the product, nothing else. So in design, we only cover the appearance of the product. Design of a bucket, design of any box, anything can be there. But I'm again saying, not the functionality. This is also a type of IP that is covered under intellectual property rights. So again, a design infringement case, Apple versus Samsung. So Apple was having a design application D593087, and Apple filed an infringement case against Samsung that Samsung, without taking consent from Apple, used their protected design. See the similarity between the protected design at the left and the Samsung Galaxy series at the right. See the similarity between the design. So Apple design was protected under intellectual property rights, and Samsung, without taking permission, without taking license, without taking consent from Apple, used the similar design in the Galaxy series, Samsung Galaxy series. So royalties of $399 million were being paid to Apple by Samsung for using the design only. So again, you can file for anything, any product, any shape. Maybe don't go for functionality. Overall appearance of the product, you can file for it in design. Design of jewelry, design of any product or any article, design of a mouse, design of a chair, design of a furniture article, anything. You can file for anything. Any questions regarding design till now? The next part is patent. Patent is also a type of protection, IP rights, and exclusive rights granted for an invention or an inventive idea which can be a process. I am taking example of infrared heater, a process of making infrared heater, a machine for making infrared heaters, an article. An article can be infrared heater, a composition of matter, any drug, any pharmaceutical product, an improvement of an invention in one of the other four classes. Means, suppose Paminda ma'am is coming up with some improved invention. I would say she is coming up with some dyeing machine that was earlier working at 100 degrees Celsius temperature. Now she is coming up improvement of the existing invention. So improvement is that the similar dyeing machine is now working at 30 degrees Celsius temperature with 5 times more efficiency. So A patent is granted for a process or a method or an article or a composition, drug, or maybe any improvement over the existing product. And this type of IP or this patent protection is given for a period of 20 years from the date of filing. So a patent is for a process, a patent for a functionality, a patent for an article. So this is patent. What are the three requirements for getting a grant? Not for filing, for getting a grant of a patent. Non-obviousness. What is the new unexpected result in it? Novelty. What is the unique feature in this? If Parminder ma'am has come up with an invention that is improving the existing invention, so what novel feature that ma'am introduced in that dyeing machine that makes the dyeing machine working on 30 degrees Celsius temperature? What is the unique feature or unique element that is being introduced in that dyeing machine that is now working at 30 degrees Celsius temperature? What is the unique feature of your invention? Again, uh, the third part is utility. What is the functionality of your invention? The difference between design and patent is that I was saying a chair in design, I was saying a chair with a 5 leg, a chair with a 6 leg, a chair with a 4 leg. But in that can be given in design. But in patents, we say what is the functionality of a chair with a 5 leg or chair with a 6 leg? So there is a difference between design and patent. For getting a patent, you need to have these three. These three are the requirements: non-obviousness, novelty, what is the uniqueness, utility, what is the functionality of that your product or your service. So let's take an example that covers all these three things. So again, Parminder ma'am is coming up with some robotic cleaning system having artificial intelligence algorithm running uh, uh, that is working on artificial intelligence. So the robotic cleaning system having some main module having some suction means that is working on artificial intelligence. So the robotic cleaning system having detachable and expandable wings over it, and the same robotic cleaning system having one smell sensor, having one GPS navigation module, having one controller in it, and along with that having some suction module in it. So the robotic cleaning system in this, first the smell sensor will smell the garbage in a proximity of 100 meters or 200 meters. So after getting an input by the smell sensor, the controller using GPS navigation module will navigate the robotic cleaning system in that direction from where the smell is coming. After reaching that place from where the smell was coming, the expandable and collapsible wings will suck in all the dust over all the garbage into the suction module or the suction tab within the robotic cleaning system. So the robotic cleaning system at this time, the robotic cleaning system is my invented product having functionality that is covering or cleaning a surface within a proximity of 100 meters or 200 meters. Along with that, what is the novelty of that? What is the novel feature or novel system element that you are introducing that were not earlier available? So we are coming up with some artificial intelligence algorithm that is working along with GPS navigation module plus some smell sensor along with detachable and collapsible wings that will work accordingly based on the controller. So that is my invention. That can be my invention. That can be anyone's invention. That is novel, unique, having some functionality that is not present earlier. That doesn't mean an invention doesn't mean that you combine or reuse some already known substance. A desperin is already there for curing the headache. So this salt is already available in the market. So no one can claim that now this same salt is used to cure body ache also, or maybe fever also. What new invention you have? What the substance is already there. The drug was already there. You have just got the news, or you have done the experiment that this can be also be used for body ache or fever also, or already known substances were there, but the functionality, you have changed the functionality, but you have not changed the product. The product is still there. The similar products are already available there, but you have only changed the functionality, nothing else. So this is not a patent. Patent is something new, something inventive, something innovative. So what is the innovative idea you are having for which you are going for a patent? What is the procedure for filing a patent application in India? Many of faculty members, I have seen that already filed a patent application, and many patents also being granted to some of the faculty members in your college. But what is the procedure for filing a patent application? In conventional manner, first we have to file a provisional, that is complete or incomplete specification. After filing complete specification, within a period of 18 months, your patent application is being published. After publication, you can go for examination, patent examination. And after examination, the controller or the examiner of the patent office will examine your invention or your patent application. And based on your submitted patent application, few objections or rejection will be raised, and few hearings will be there, and after that your patent will be granted or rejected based on the observation made by examiner. So this in a conventional manner, this whole procedure takes around 3 to 4 years, but in an expedite manner it can be done in 1 year also. So after filing complete specification, as in conventional manner it was taking 18 months, it can be uh, published earlier also, early publication. In this, within 30 days your patent application is published, and after that you can go for expedite examination. In expedite examination, it will take around 1 to 2 months for the examiner to respond your query, or to respond your examination request. So it won't take more than 1 to 2 years for your application to get granted or rejected, whatever the result is. India's first patent was granted to George the Penning, an efficient Pankha pulling system in 1856. So India's first patent was granted to George the Penning. Another patent example by Sony for their PlayStations or gaming, that you can convert any nearby object into a remote, a fruit, a spectacle, or spectacle cover, or a mouse, or your mobile phone into a remote. How they are doing it, they have mentioned in the patent itself, patent application itself. As Apple is coming up with single glass desktop with detachable keyboard. Again, a novel invention by Apple. In 2000, by 2012, Harideshwar Singh was the youngest patent holder in India. He invented 6, 12, and 60 player chessboard. So, age is not the limit, invention is not the limit. Anyone from anywhere of any domain can file a patent application. Dyson is coming up with air purifier headphones that will purify the headphones will purify the air that is coming onto your face. Again, a novel invention. So another case, this is patent infringement case. Earlier we discussed design infringement case between Apple and Samsung. The same patent infringement case between Apple and Samsung. Apple was having patents that is bounce back scroll, zooming with 2 fingers, scrolling with 1 finger, and patents was 7469 381 7844 915 7864 163. So Apple was having a protected invention, or they were having patents. Samsung used their protected invention in their Galaxy series. So the USPTO asked the Samsung to pay a royalties of $539 million to Apple for using their protected invention. So this invention was protected. That is why our royalties were being paid to Apple. The design was protected. That is why the royalties were being paid to Apple. So if you want someone to not to use your invention, you need to protect your invention. If you are planning to start your own setup, or maybe you are planning for your startup, you need to file a patent application before starting anything, to avoid any clashes, or to avoid any competitor, or to avoid anyone from copy or to uh, come up maybe any competitor coming up with a similar product or similar service. So before launching your product or any method or any startup, try to protect your invention. Some myths is it's compulsory to have a prototype. It's not like that. Even an idea, we can go for a patent application with an idea also. Getting a patent is a big task. Getting your idea is a big task. Not getting a patent is a big task. Only domain specific applicants can apply. This is nothing like that. Anyone, I think you are from computers domain, most of you. So you can file for anything. You can file in mechanical, biotech, any domain. There is no limitation to it. Patents are enforceable worldwide. There's nothing like that. Patents are enforceable in your native country only. So if you want to go worldwide, you have to file it separately. Suppose you have filed in India, these patents are enforceable in India only, not in any other country. Microsoft is also having a patent. It's also having many patents, out of which is opening up of a new window from right click. We use many e-commerce. We do shopping on many e-commerce websites. So every e-commerce website having their one-click buying tool. So that was basically with the Amazon only initially. Michael Jackson was also having a patent for his famous footwear that allows him to basically bend up to a certain level, up to a certain degree. So patent you can file for anything; it will be granted. That doesn't mean it needs to have a complex, any complex issue or any statement regarding this. Some funny and weird patents: a device for holding the mustache out of the way in eating or drinking. This patent was granted in way back in 1950, 1960. Device for waking person from sleep. In this invention, or a light frame in such a position that it will hang directly over the head of the sleeper, the suspending cord being combined with the automatic releasing device, whereby the frame is at the proper time permitted to fall into the sleeper face. And anti-eating face mask, which includes a cup-shaped member conforming to the shape of the mouth and chin area of the user, that will restrict the user for intaking any food from outside. So both, but these are weird, kind of 100 or to maybe many thousand weird inventions are there. So that totally depends upon you. What is your invention? Maybe you think that may be weird, but for maybe it will be granted if it is solving some purpose and it was not known to the public earlier. It may be granted. What are non-patentable items? Any obvious known invention, anything that is really injurious to human, animal, or plant life, it is not patentable. Discovery of anything is not patentable. Uh, a new substance made by mixing some old, mixing or remixing of something, arrangement of rearrangement of something is not patentable. Method of agriculture or horticulture, not system for agriculture. खेती करने का तरीका is not patentable. Not system that are being used for agriculture or horticulture. And any mathematical or business method patent. So business method, I would say, I take example of Uber, Zomato, Swiggy, Ola. So these are services, business method. So in India, business method patents are not patentable. See, in India, these are services. So these are not patentable. So, but that doesn't mean they can't file a patent application. They have their their granted patents in India. The thing is, look at the backend operation. That one mobile terminal is connected with the other mobile terminal for a service through a cloud within a proximity of 5 kilometers, and all these are working on artificial intelligence algorithm and having some hardware assistance also. So the look at the backend operation, that is patentable, not the service. That is why many applications are right now in India are coming up that giving you 2 minute service, 2 minute grocery service, 2 minute ambulance service. You can easily go for that. That doesn't mean that in service sector in India it is not patentable. You can file for it, but you won't be getting any patent over it. But if you have any idea of any app or any such, you can certainly go for it. You don't have to restrict it via these apps. The backend operation, the hardware operation, or the that includes any process or method involved, you can certainly go for a patent. But the service that you are providing, you can't have a patent over it. Methods of playing games, any algorithm, anything related to atomic energy, weaponry art, rare earth material is not patentable in India. And any biological production or reproduction is not patentable in India. So this was basic patent, or what are patents, what are the requirements, what is the procedure for filing a patent, So some basic patents, examples of patents were there. What are the non-patentable items? So this was patents. Any questions regarding this, regarding patents, please? Any questions regarding this?
Yes, anyone? If anyone want to ask any question?
Or shall I proceed now?
Yes, sir.
Yeah. Another type of IP, basically, that is for a company, trade secrets. Basically, this type of IP is basically between the company and the native government. NDA is basically non-disclosure agreement signed between the native country and the company to not to disclose their invention for their competitive edge. So we have Maggie, we have Top Amazon, we have Zing Chinese, we have EP noodles. All are noodle products, but every noodle product is quite distinct in taste. So basically, NDA is being signed between the company. No one is able to match the taste of Maggie. So this is due to trade secrets. Difference between the taste of Coke, Pepsi, and Thumbs Up. Difference between the sausages of Burger King, KFC, and McDonald's. Difference between Fanta and Mirinda. Difference between if you look around yourself, we have many search engines. Google is there, Firefox is there, Bing is there, Yahoo is there. Many search engines are there. So a reverse engineering is possible, but ethically it won't be leaked by any professional or by any authority, government authority. So there is a difference between each and every competitive product. So why there is a difference? Because reverse engineering is possible, but they have signed a trade secret with the native country to not disclose their invention. Similarly, you won't see anything related to weaponry art. Google पे मिल जाएगा आपको that how to make a bomb or something like that. But ethically, any known company, you won't be getting anything. Russian art आपको नहीं मिलेगी कभी भी. Weaponry art, you won't get anything. You won't get anything that is related to DRDO, ISRO, that is dealing in weaponry art or anything from the US side. The one who are dealing in this, you won't get anything that is working on the rare earth material. So that is quite subjective, that or confidential, that this thing won't be out to anyone else in the market. That is basically trade secrets that no government wants to take it out. Another is a geographical indication. Basically, this type of IP is given for a product, not to an individual. Basically, Kullu shawls, Darjeeling tea, Amritsari kulcha, basically a product that is originated from a place. Mysore silk. In India, around 16 or 17 types of silks are there. So if someone is claiming, some shop owner is claiming that this silk is Mysore silk, or this is this is Kashmiri shawls or Kullu shawls is there, or any product. So he or she, or the product owner, is claiming the GI, geographical indication, that this product originally belongs to any geographic location. So basically, this type of IP is basically for a product, not for any individual. A similar case was going on between, I think, Bengal and Odisha, or Bengal or Assam, regarding Rasgulla. So basically, the place from where the product is originated. So this is not belongs to you, but it is a kind of IP. A single product, multiple IPs. I quoted one example of Tata Tigor car. Tata is a product, is a brand name. Tigor is a product name, comes under trademark. If you see the overall structure of the product, the structure comes under the design. The functionality comes under the patents. So single product, multiple IPs. We quoted one example of Oreo regarding the trademark trademark infringement. Similarly, look at the packaging of Haldiram. It is also comes under trademark. A design of a washing machine, a design of a table, a design of any furniture article, a design of a speaker. Books by Chetan Bhagat. That is a copyright. IC layouts. IC layout in India, only 2 IC layouts are being given only to the Bell Panchkula, I think. Again, one product that is mobile, having multiple functionality, that is of camera, trademark, LCD, and round corners comes into the design. Camera is a kind of another patented invention. So we have, if you see at the back end, Nokia was bankrupt in 2013, but he sell out his patent portfolio for 1 year to Microsoft. Where is Motorola? Where is Fujifilm? Where is Kodak right now? Where is STC? Where is Sony Ericsson? So everyone, where is STC? So everyone thinks that they are now bankrupt and they are being closed. But at the back end, they were having a strong portfolio, patent portfolio. Now what they are doing? They are enjoying the royalties. Nokia was having the maximum number of patents in CDMA, GSM, in mobile communications. Kodak, Fujifilm was having many basic patents of photography. Suppose you travel by a car, we have airbags. So all the royalties right now of airbags are being paid to Volkswagen. Many royalties regarding your your mobile phone are being paid to Motorola. So every industry, every company is having their strong patent portfolio. Even I have seen your institute is also having a quite heavy patent portfolio that were being filed in the market. So to enjoy the royalties, to enjoy it, or to stop anyone from using your invention, you need to protect your invention. You need to file for copyright. You need to file for design. You need to file for any patent. So how we are doing it, what we are doing it, basically IP Guide partners along with me, we are helping out students, startups, and faculty members to file their IP in India and file not only patents, we are dealing in copyright, trademarks, and designs also. Trademark is basically for startups, not for any other else. If you don't have any product or any brand name that you are starting up, so trademark doesn't help, that won't be helping you out. But you have any research paper, you want to go for copyright, or you want to go for any design, we can easily help you out. You can contact me anytime regarding this. If you need any assistance regarding this. Right now, if you are having questions regarding this session, please ask me. Please feel free to ask me, because your institute has given me opportunity to clear your doubts or clear the whatever questions you have. So please feel free to answer to ask me any questions regarding patents, copyright, design, anything you have regarding this.
So if I have some design, then I should go for a patent protection or for the trademark protection.
Ma'am, basically, design is basically for a product, and trademark is basically for a brand name.
Okay.
Okay, so a design having a name. While filing a trademark, what will you name that? Name that design. Suppose I take your initials of P. Suppose P is the design. Now you want to file a trademark with that, but that won't be giving you protection of a design. It will
Okay.
cover only the trademark, the brand name. It will cover the brand name, not the design. Both are different types of
The
IP.
product.
Design is basically the shape of the product. So in trademark we cover brand name, not product, not the shape of the product. Only the name that is being used that will be used by you. In design, we cover the shape of the product. Product can be
Okay.
anything. Okay, ma'am.
So for that, I should go for patent protection or
Design
design
protection.
protection. Okay.
Design.
It is a
You can go
separate
for
IP.
you can go for two things. The functionality can be covered in patent. The
Patent.
overall
Okay.
appearance of can be covered in design.
Design. Okay. Thank you so much, sir.
In design, we have seven figures. If students are there, they have a subject ED in their first or second semester. So they already know we cover seven views in this: perspective, front, back, left, right, top, bottom for a product. Any questions regarding anything?
Yes, everyone, if you have any doubt, a simple one or a big one, you can ask, please. The session is open for you. I don't think they have any questions, so I think we
No
should
issues, ma'am.
end up the session right here. Thank you so much, sir. Thank you so much for a fruitful and a valuable insights you have provided about the subject with in-depth knowledge and with the brilliant examples. The way you have explored the subject is really
Thank you, ma'am.
Alveer Singh team, sir, to please deliver.
Okay, okay, good afternoon, everyone. My voice is audible?
Yes, sir.
Okay, so it has been a really nice session, and all the things, just 1 minute. And all the things are related with the uh, trademarks, copyrights, and patents have been well elaborated and discussed by Mr. Jasprit Singh, founder and CEO, IP Quad company. I'm really grateful to Mr. Jasprit Singh for sharing his vast knowledge and experience, which has we already know through his resume, which came to us and was discussed also. And we would like to have further discussions regarding same for the students and for the faculty in the future also. We'll keep in touch with you. And
Sure, sir.
many students have also joined regarding same, and faculty have joined. So I am very much hopeful that further all these things will be incorporated, and all students and faculty members, they have got an idea about the exposure about the various things which can be dealt with patents, copyrights, trademarks, and the differences between them, and the applications regarding how they can further apply for, register for, and get their patents published. And we'll have some like projects will be discussed with you. Mr. Jaspreet Singh will follow up for the same, so that how we can further enhance those things which will be very useful for the institute level also, and for the department level also. And regarding the participants, I would again request everyone to fill the feedback form. There are 2 feedback forms, and I think Rupinder Kaur has shared that, Professor Rupinder Kaur. And one is from the institute level, and one is from Mr. Jaspreet Singh. Okay, both need to be filled up. And second is, I request again all the students and faculty members to subscribe for the CSC YouTube channel, and we'll share this video on the same. Otherwise, it is again always live, but due to some technical issues, this session was not held live, but we'll still put all the information on YouTube channel. So further, for all regular updates regarding the programs which are organized till now, the expert talks delivered from international speakers and national speakers from academia and research, all have been shared there, and we are counting near about 500 subscribers for that. For information regarding Department of Computer Science and Engineering at Baba Banda Singh Bahadur Engineering College, Fatehgarh Sahib, Punjab, we had recently been accredited. Our BTech CSC has been accredited by National Board of Accreditation (NBA), and we are really proud to share this information among all that we are the only college in Tier 2 colleges all over Punjab which is having NBA accredited BTech CSC. Otherwise, University Thapar is having, but from the college side in Punjab, we are the only one. And more things like that, and even we can. What I have found is like it's almost all things have been covered by Mr. Jaspreet Singh, but still. How to use them in projects, how to follow up related with the research work, the papers we have been doing, the journal conferences, how we can further collaborate regarding the same. We'll discuss more about that, and hopefully we'll be having one more webinar. I would request again Mr. Jaspreet Singh to have the series 2 for this particular webinar. Okay, so it will be continued in the near future also. So, Professor Parminder Kaur, the organizer of this particular event, and Professor Rupinder Kaur and Professor Devjot Kaur all have done wonderful organizing for this successful, for being this event successful. So I really appreciate their efforts. So thank you everyone. So with that, I think Professor Rupinder Kaur will continue. Anything further? Okay, thank you everyone.
Thank you, sir. Thank you so much for your views and for sharing your valuable insights also related to the subject. So thank you so much, sir. Thank you, Jaspreet Singh, sir, for being part of this webinar. And definitely we'll have the opportunity and we'll have that pleasure to be with us for in future as well. Thank you, sir.
Sure, ma'am. Anytime. Thank you.
Thank you all the participants for their cooperation and patience. Thank you. We'll end up the session now. Thank you.
Thank you.